What if I told you that the family immigration process you've been relying on for years is about to change dramatically? Thousands of families across America are waking up to the reality that bringing their loved ones to the United States just got significantly more complicated. In January 2026, the Trump administration has announced major changes to I-130 family petition rules that could affect your ability to sponsor parents, siblings, spouses, and children. If you have a pending petition or plan to file one, the next few minutes could determine whether your family stays together or remains separated for years to come. Hello, everyone. You're watching Move and Earn USA, and I'm your host, Gabriel, bringing you the most critical updates on American immigration, visas, and policy changes that directly impact your future in the United States. Today, we're breaking down the Trump administration's latest announcement regarding family-based immigration and the I-130 petition process. These changes are set to take effect in early 2026. And if you don't understand what's happening, you could face massive delays, denials, or even permanent separation from your family members. Make sure you watch this video until the very end. Take notes, and please subscribe to Move and Earn USA so you never miss an important immigration update that could change your life. Let me start by explaining what the I-130 petition is and why it's so critical to family immigration in America. The I-130, officially called the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form that U.S. citizens and lawful permanent residents file with USCIS to establish a qualifying relationship with a foreign family member. Once the I-130 is approved, it proves that you have a valid family relationship, and your relative can then apply for an immigrant visa or adjust their status to become a permanent resident. The I-130 covers various family relationships, including immediate relatives like spouses, unmarried children under 21, and parents of U.S. citizens, as well as preference categories for siblings, married children, and adult children. For decades, family reunification has been a cornerstone of American immigration policy. Millions of immigrants have used the I-130 process to bring their loved ones to America legally. But in January 2026, the Trump administration has announced significant policy changes that are reshaping how these petitions are processed, evaluated, and approved. These aren't minor technical adjustments. These are fundamental shifts in policy that reflect the administration's broader approach to immigration enforcement and its goal to reduce overall immigration numbers, particularly in family-based categories. The first major change involves significantly increased scrutiny and documentation requirements for I-130 petitions. Under the new guidelines, USCIS is requiring petitioners to submit substantially more evidence to prove the legitimacy of family relationships. In the past, basic documents like birth certificates, marriage certificates, and proof of the petitioner's citizenship or permanent residency were usually sufficient for straightforward cases. Now, the Trump administration is implementing what they call enhanced vetting procedures. This means even routine I-130 petitions will face much more intensive review. USCIS is now requiring extensive documentation of the relationship's history, financial interdependence for spousal petitions, detailed affidavits from third parties, photographic evidence spanning the entire relationship, and in many cases, certified translations of foreign documents from approved translators. What this means in practical terms is that preparing an I-130 petition has become significantly more complex and expensive. You may need to hire immigration attorneys or consultants to help compile the required evidence. You'll need to obtain official translations of documents. You'll need to collect affidavits from friends, family members, and colleagues who can attest to your relationship. And even with all this additional documentation, Processing times are increasing because USCIS officers are spending more time reviewing each petition. Cases that used to be approved in 6 to 12 months are now taking 18 months or longer. And that's just for the I-130 approval, not the entire immigration process. The second major change involves stricter financial requirements for sponsors. When you file an I-130 petition, you're not just proving a family relationship, you're also committing to financially support your relatives so they don't become a public charge in America. This is done through Form I-864, the Affidavit of Support. Under previous administrations, the income requirement was set at 125% of the federal poverty guidelines for your household size. If you didn't meet this threshold, you could use a joint sponsor, typically another family member or friend who met the income requirements. The Trump administration is now making significant changes to these financial requirements. First, the income threshold is being raised. While the exact new percentage hasn't been finalized, proposals suggest it could increase to 150% or even higher of the poverty guidelines. Second, the administration is limiting the use of joint sponsors, making it harder to qualify if you personally don't meet the income requirements. Third, they're scrutinizing assets more carefully, and simply having assets may not be enough to overcome income deficiencies. Let me give you a concrete example of how this affects real families. Under the current guidelines, if you're a U.S. citizen sponsoring just your spouse, you need to show income of at least $28,000 per year based on 125% of the poverty guideline for a household of two. That's already challenging for many Americans, especially those in lower wage jobs or who are recently unemployed. Now, if the threshold increases to 150%, you'd need to show income of approximately $33,000 or more. And if you're sponsoring multiple family members, your parents and your spouse, for example, the required income jumps significantly higher. For a household of four, you could be looking at income requirements of $50,000 or more annually. Many American families simply don't earn this much, especially in lower-cost areas of the country or in industries with lower wages. This effectively prices out working-class and lower-middle-class Americans from sponsoring their family members. The third major change involves expanded grounds for denial and increased use of requests for evidence, RFEs. RFEs are notices from USCIS asking for additional information or documentation before they can make a decision on your petition. In recent years, the rate of RFEs has skyrocketed under the Trump administration's policies. What used to be straightforward approvals are now resulting in RFEs that require petitioners to submit additional evidence, clarify discrepancies, or explain elements of their case that USCIS finds questionable. The new 2026 guidelines expand the grounds on which USCIS can issue RFEs or outright deny I-130 petitions. USCIS officers now have broader discretion to question the bona fides of relationships. They can deny petitions based on subjective assessments of whether a marriage seems genuine, whether family ties are sufficiently strong, or whether the petitioner has demonstrated adequate commitment to supporting their relative. Additionally, the Trump administration has instructed USCIS to take a much harder line on any inconsistencies or discrepancies in applications, no matter how minor. A small error in a date, a discrepancy between how you spelled a name on one form versus another, failing to list a previous address from many years ago. These kinds of minor issues that were previously overlooked or easily corrected are now being used as grounds for RFEs or denials. The message is clear. The administration wants to make the family immigration process as difficult as possible, hoping that increased complexity, cost, and uncertainty will discourage people from even attempting to sponsor family members. Another critical change involves the priority date system and visa bulletin retrogression for family preference categories. There are annual numerical limits on how many visas can be issued. This creates backlogs, especially for countries like Mexico, Philippines, India, and China that have high demand. The priority date is the date your I-130 petition is filed, and it determines your place in line. You can only proceed with the visa application or adjustment of status when your priority date becomes current, according to the monthly visa bulletin. Under the Trump administration, we're seeing deliberate slowdowns in how quickly priority dates are advancing. The State Department, which manages the visa bulletin, is under pressure from the administration to slow down family immigration. This means even if your I-130 is approved, you could wait many additional years before you can actually bring your family member to America. For siblings of U.S. citizens from countries like the Philippines, the wait times are already exceeding 20 years. Under the new policies, these wait times could stretch to 25 or even 30 years. The fifth major change involves increased scrutiny of adjustment of status applications for immediate relatives already in the United States. Many people file I-130 petitions for spouses or children who are already in America, perhaps on tourist visas, student visas, or even without legal status. Historically, immediate relatives of U.S. citizens, which include spouses, parents, and unmarried children under 21, could adjust their status to permanent residency, even if they had periods of unlawful presence, as long as they had an approved I-130 and met other requirements. The Trump administration is now cracking down on these cases. USCIS is taking a much stricter view of visa overstays and unlawful presence. Even immediate relatives are facing increased scrutiny, longer processing times, and higher denial rates. Officers are looking for any reason to deny adjustment applications, including minor violations of status, gaps in documentation, or perceived fraud. If your spouse entered the U.S. on a tourist visa and you got married shortly after, USCIS may suspect visa fraud and subject your case to extensive investigation. Let me also address the impact on specific family categories. For U.S. citizens sponsoring spouses, the new rules mean you need to prove your marriage is genuine with extensive evidence. USCIS is conducting more in-person interviews, asking detailed questions about your relationship, your daily life together, your finances, and your future plans. They're looking for any inconsistency that might suggest a fraudulent marriage. For U.S. citizens sponsoring parents, you'll face the same enhanced documentation requirements and financial scrutiny. Additionally, if your parents have any immigration violations in their past, such as previous unlawful presence or visa overstays, these issues will be examined much more critically. For lawful permanent residents sponsoring spouses and unmarried children, the challenges are even greater. You're subject to the family preference system, which means longer wait times. You also face the heightened financial requirements. And because you're a permanent resident and not a citizen, USCIS may scrutinize your own status more carefully to ensure you're maintaining your permanent residency. For siblings of U.S. citizens, the situation is particularly difficult. The sibling category, known as F4, already has the longest wait times of any family preference category. With the new policies, not only are wait times extending, but there's also discussion within the administration about potentially eliminating the sibling category altogether. While this would require congressional action and hasn't happened yet, the fact that it's being discussed shows the administration's intent to dramatically reduce family-based immigration. Now let's talk about what you can do to navigate these changes and protect your family's immigration prospects. First and foremost, if you're planning to file an I-130 petition, do it as soon as possible. Your priority date is established when you file. So, filing sooner rather than later locks in your place in line. Every month you delay is another month added to your overall wait time. Second, prepare the most thorough and comprehensive petition package possible. Don't just submit the minimum required documents. Include extensive evidence of your relationship, detailed affidavits, photographs, communication records, financial documents showing joint accounts or interdependence, and any other evidence that demonstrates the legitimacy of your family relationship. Third, seriously consider hiring an experienced immigration attorney. With the increased complexity and scrutiny, having professional legal help is more important than ever. An attorney can review your case, identify potential issues, prepare you for interviews, and respond to RFEs effectively. Fourth, make absolutely sure you meet the financial requirements. Review your income carefully. If you're close to the threshold, consider getting a joint sponsor lined up in advance. If you're using assets to meet the requirement, understand that USCIS is scrutinizing these more carefully, and you need to show that assets are liquid and readily available. Fifth, be completely honest and accurate on all forms. With the increased scrutiny, any false statements or material omissions can result in denial and potential permanent bars to immigration. Even honest mistakes can cause problems. So triple check everything before submitting. Sixth, respond to any RFE quickly and thoroughly. If USCIS issues a request for evidence, you typically have a limited time to respond, often just 30 to 60 days. Use this time wisely, provide all requested documentation and more. Address every concern USCIS raised. If you're unsure how to respond, get legal help immediately. It's also important to understand your rights and options if your I-130 petition is denied. You generally have the right to appeal a denial or file a motion to reopen or reconsider. However, appeals are complex and time-sensitive, so you need legal assistance. In some cases, it may be better to address the reasons for denial and file a new petition rather than appealing. This depends on the specific circumstances of your case. Also, stay informed about policy changes. Immigration policy under the Trump administration is evolving rapidly. What's true today may change in a few months. Follow reliable sources like Move and Earn USA, where we break down these changes and explain what they mean for you. Don't rely on rumors or unverified information from social media or friends. Immigration law is complex, and bad advice can ruin your case. For those of you with pending I-130 petitions filed before these new rules took effect, understand that USCIS may apply new standards to your pending case. Even if you filed under the old rules, your petition could be subject to the new scrutiny and requirements. If USCIS issues an RFE on your pending petition asking for additional evidence, that's the new policies being applied to your case. You need to respond appropriately. For those considering other immigration options, understand that family-based immigration isn't the only path. Depending on your situation, you might explore employment-based immigration, the diversity visa lottery, humanitarian programs like asylum or refugee status, or in some cases returning to your home country and applying for visas from there. Each option has its own requirements and challenges, but it's worth exploring all possibilities. Let me also address some common mistakes people make with I-130 petitions that become even more costly under the new strict rules. First, rushing the application. People get excited about bringing family members to America and submit incomplete or poorly prepared petitions. Take your time, gather all evidence, and submit a complete package. Second, not being truthful about previous immigration violations. If your relative overstayed a visa, was denied entry, or had other immigration issues, disclose this up front. USCIS will discover it anyway, and failing to disclose can be considered fraud. Third, not maintaining status while the petition is pending. If your relative is in the U.S. while the I-130 is pending, they need to maintain legal status. Falling out of status can jeopardize the entire case. Fourth, not updating USCIS about changes. If you move, change jobs, or have other significant life changes while your petition is pending, notify USCIS. Failure to update your address could mean you miss important notices. The Trump administration's approach to family immigration represents a fundamental shift in American policy. For decades, both Republican and Democratic administrations generally supported family reunification as a core principle of immigration. The current administration is moving away from this principle, viewing family based immigration as chain migration that they want to limit or eliminate. Understanding this context is important because it helps you realize that these policy changes aren't just bureaucratic adjustments. They're part of a deliberate strategy to reduce legal immigration overall. This means you can expect continued tightening of rules, increased enforcement, and more obstacles in the family immigration process as long as these policies remain in effect. Friends, I want to be completely honest with you. These changes make family immigration significantly harder. The process that was already stressful, expensive, and time consuming is now even more challenging. Many families will face separation for longer periods. Some petitions that would have been approved in the past will now be denied. The financial barriers will prevent some Americans from sponsoring their loved ones at all. This is the reality we're facing in 2026. However, I don't want you to lose hope. Thousands of families are still successfully navigating this process every year. With proper preparation, good legal advice, patience, and persistence, you can still bring your family members to America legally. It's just going to require more effort, more documentation, and more time than before. Here on Move and Earn USA, we're committed to helping you understand these complex immigration changes and giving you the practical information you need to make informed decisions. We'll continue monitoring Trump administration policies, breaking down new announcements, and explaining exactly how they affect you. Immigration law is our focus, and we're here to be your trusted source of accurate, up-to-date information. If you found this video helpful, please hit that like button and share it with anyone who might be going through the family immigration process. They need to know about these changes. Subscribe to Move and Earn USA and turn on notifications so you don't miss our next update. Immigration policies are changing rapidly, and staying informed is your best protection. Drop a comment below if you have questions about your specific situation or if there are other immigration topics you'd like us to cover. I read every comment, and your feedback helps me create content that addresses your real concerns. Remember, knowledge is power when it comes to immigration. The families who succeed are the ones who understand the rules, prepare thoroughly, and take action strategically. Don't wait until it's too late. If you're planning to sponsor a family member, start preparing now. Gather your documents, assess your financial situation, and if needed, consult with an immigration attorney. The sooner you act, the better your chances of success. This is Gabriel from Move and Earn USA, and I'll see you in the next video. Stay informed, stay prepared, and never give up on bringing your family together. Take care.